Life Esidimeni Saga, Arbitration and Inquest. Introduction. The Life Esidimeni tragedy remains one of the most harrowing and instructive chapters in post-apartheid South African governance, human rights, and public health administration. In 2016, the Gauteng Department of Health abruptly terminated its service-level agreement with Life Esidimeni Care Center, a long-term psychiatric care institution, leading to the transfer of thousands of mentally ill patients to unlicensed and ill-equipped non-governmental organizations, NGOs. Over time, at least 141 of these vulnerable mental health care users died under circumstances that would shock the conscience of the nation and expose systemic failures in duty of care. These deaths sparked a judicial arbitration and later a judicial inquest, both designed to address accountability, uncover truth, and offer avenues for justice and closure. But what exactly is arbitration? What is a judicial inquest in the South African context? Why were these processes chosen, and how did they influence the trajectory of justice for the Life Esidimeni families? What is arbitration? Arbitration is a form of alternative dispute resolution whereby disputing parties agree to forego conventional litigation and instead submit their dispute to an impartial third party, the arbitrator, who hears evidence and submissions and issues a binding decision known as an arbitration award. Arbitration is consensual and contractual in nature and provides a mechanism for resolving disputes outside ordinary court proceedings, but with legal finality comparable to judicial outcomes. In South Africa, arbitration is governed by the Arbitration Act 42 of 1965, which requires a written agreement to refer a dispute to arbitration and empowers an appointed arbitrator to determine the dispute and issue awards enforceable under law. The Life Esidimeni arbitration, led by retired Deputy Chief Justice Dikgang Mosnik, was such a process. The state and families consented to arbitrate. Evidence and testimony were heard over many days, and an award, including compensation for constitutional damages, was rendered in favor of the affected families. What is a judicial inquest in South Africa? A judicial inquest, as established under the Inquest Act 58 of 1959, is a judicial inquiry into deaths that are sudden, unexplained, or due to causes other than natural circumstances. In South African law, an inquest does not determine guilt or punishment, but is an inquisitorial process aimed at uncovering the truth about the circumstances surrounding an unnatural death, the identity of the deceased, the date and cause of death, and whether the death was brought about by act or omission that could constitute an offense. Unlike criminal trials, inquests do not involve an accused person and do not require proof beyond a reasonable doubt. Rather, they serve to establish facts in a transparent and public process that may assist prosecutorial decisions or prevent future harm. The arbitration, truth and remedies. The Life Esidimeni arbitration, convened from October 2017 to February 2018, was a watershed moment in South African legal and constitutional history. Chaired by Mosnik, the proceedings were broadcast live, allowing the nation to witness families and advocates confront government actions and systemic negligence firsthand. Evidence from over 60 witnesses painted a grim picture of bureaucratic indifference, inadequate planning, and egregious violations of dignity, security, and access to healthcare rights. Mosnick's award found that the decision to terminate Life Esidimeni's contract and the subsequent mass transfer of mental health care users were irrational, unlawful, and in blatant breach of constitutional rights. He ordered the state to pay constitutional damages, typically valued at around $1 million per claimant, reflecting the severe violation of fundamental rights. Aside from compensation, the award included important remedial recommendations, funeral cost contributions, counseling and support services for families, development of a mental health recovery plan, and recommendations for broader accountability and structural reforms. For many families, arbitration was their first formal recognition that the deaths were not simply tragic accidents, but consequences of unlawful administrative conduct. It provided financial recompense, but critically, it did not definitively answer questions around criminal responsibility or lead directly to prosecutions. The judicial inquest, accountability, and the quest for truth. While the arbitration addressed civil liability and reparations, it left unresolved questions about criminal culpability. In response, authorities referred the matter to a formal joint judicial inquest, which began in July 2021 and culminated in a landmark judgment in July 2024. This process, presided over by Judge Manoa Tefo in the Gauteng High Court, involved 140 days of hearings over 2.5 years, reviewing extensive evidence, including witness testimony, post-mortem reports, and records from the prior arbitration. Unlike arbitration, the inquest sought to determine whether the deaths resulted from conduct that prima facie amounted to a criminal offense. Judge Tefo's ruling held that former Gauteng Health Imikadani Malangu and the Director of Mental Health, Dr. Makabo Menemila, had negligently caused the deaths of several patients by disregarding expert advice, failing to plan adequately, and transferring patients to NGOs lacking adequate capacity. Though the inquest did not itself impose criminal sanctions, its findings of negligence and prima facie criminal conduct have significant implications. They create a judicial record that may inform prosecutorial decisions and reinforce standards of accountability in public administration. Reflection. Laws, Lives, and Legacy. The Life Esidimeni saga underscores the interplay between legal mechanisms, constitutional rights, and human dignity. Arbitration provided families with recognition and reparations for gross rights violations. The judicial inquest offered factual clarity and initial accountability for conduct leading to deaths that should never have occurred. Yet, as families and civil society continue to call for full criminal prosecutions against all responsible parties, the struggle for comprehensive accountability persists. This tragedy is not simply a chapter of legal history, but a moral and institutional reckoning, reminding South Africa that the protection of vulnerable citizens is a fundamental obligation, not a bureaucratic checkbox. The arbitration and judicial inquest, in different but complementary ways, opened paths toward justice, truth, and acknowledgement of loss. Their legacies will continue to shape debates on governance, health policy, and the rule of law for years to come.